The court always tends to make a number of observations at sentencing hearings that are contested and which carry a good deal of weight, and I'm not going to depart from that process today. I first think it's important to acknowledge that the trial and the process within this case that brings us here today was the united effort of a number of people. And first and foremost, I want to recognize again the jurors, but not just those 12 people that rendered the verdicts here, but those alternates, those people that responded to the summons, especially given the time of year that this occurred, and the concerns that were rife regarding individual health. We, as by necessity, inconvenienced a number of citizens, and in the end, when I spoke to them, they had no regrets about their service. And that is because they understood that under our system, that is vital. And they understood that they had a duty to perform once selected. So I thank them once again. I want to thank the bailiff staff who, throughout those weeks of trial, worked incredibly well in assisting the parties, the court, the witnesses, and the media. I want to thank the prosecution because I thought that the case that they presented was done efficiently, economically, but most importantly, with due deference to the nature of the evidence and the need to present that evidence in a manner which honored the people who were lost. We had a number of lay witnesses that came to court to testify. I assume that they all would rather have been somewhere else, but they all came willingly and testified here, and I appreciated their participation and the time that it took for them, again, under the circumstances, both as far as health and the nature of the proceedings and their testimony. Counsel mentioned that this crime caused a rip in our community. If there's one thing that's a positive coming out of this, I think that it is a demonstration to our community of the pride we should feel in our law enforcement, the pride we should feel in how they investigated this case and how they presented the evidence in this case. It was, well, I honestly think it put Dane County on the map through both the Justice Department efforts and the efforts of our local Sheriff's Department and other law enforcement agencies involved. It was quite incredible. I also want to finally say something about the fact that at every trial, just about, I hear defense attorneys speaking to jurors in voir dire about the fact that the defendant has a right to a trial. The defendant does not have to prove anything. The defendant does not have to testify. Sometimes the counsel will go to the extent of saying, we don't have to do anything. It's the state's burden. It's the state's responsibility to carry the case forward, to prove its case beyond a reasonable doubt. And you should find the defendant not guilty if you believe they failed in that. Attorneys Doral and Vera carried out their constitutional duty in this case efficiently. And I don't want to say too much more because of mention already about questions about the review of what they did in representing Mr. Halderson. But I wouldn't be remiss if I did not say that their actions, and I agree with Mr. Brown in this respect, that their actions at trial advanced Mr. Halderson's constitutional right to require the state to prove its case, and did so in a professional and efficient manner such that I find that they served their role in this process admirably. I'm very passionate about our system. And so let me move on to the points in this proceeding at which I need to be dispassionate. And I need to be dispassionate because as the person sitting in judgment, I have to try and achieve a proper analysis of the sentencing goals based upon the information and evidence put forward and what the legislature has determined to be the appropriate sentences, at least as far as maximums, mandatory minimums, if any, and here, obviously, as addressed by everyone, the determination of whether there should be any eligibility for parole in the future. Technically extended supervision, but it's easier just to say parole. I've had the benefit of observing everything at the trial, whether it occurred before the jury or not. I've had the benefit of reviewing all the pre-trial submissions by the parties. I've had the benefit of the pre-sentence investigation and the materials submitted by victims, orally by the state in writing, by the defense, and orally here today. And Mr. Halderson has exercised his constitutional right as well. I don't know the victims. I did not know the victims. I know people like them, I'm privileged to say, and I know and can understand the empty space that this crime has left. I can empathize. I can only partially understand the feelings because I haven't lost people in my family through such a manner or had a violation by a member of the family causing such loss. But everyone in this room has a mother and a father. Everyone has siblings, if they're fortunate, and everyone can understand the loss that the Halderson family, extended as it is, and their friends, and this community feel for their loss. It is tragic. It is tragic. It is something which will take decades for some to heal. I hope not that long, but healing may never come for some. One does not know. And I hope that no one is coming here for that healing. This procedure provides closure only of this legal part of the matter. What people can do in their own lives to address their loss is what they must do themselves and amongst others. But I do want you to know that this court honors your loss, honors the people who died, and approaches this sentencing here, weighing that gravity of that offense as one of those things which must be weighed in determining whether or not Mr. Halderson should ever be eligible for parole, as the life sentences I must impose are predetermined by the legislature. It is true that rehabilitation is a factor that must be considered, and Attorney Brown's point is well noted, that I'm not certain that anyone has identified rehabilitative needs, but those may arise over time, depending upon an individual's receptiveness and willingness to participate in self-examination or diagnosis or other steps which our criminal justice system utilizes to try and determine how to fix something, whether it's a substance abuse issue or an anger issue or something that is only amenable to treatment by medication or intensive therapy. Some people, I believe, can't be fixed. I have no basis to know whether Mr. Halderson fits into any of those categories, other than I think it's fairly clear here that nothing was identified in his 23, 24 years of life up to this point, except for his actions in July. And to an extent, his actions over the year plus leading up to that, where he was deceiving his family and his friends. The gravity of the offense is as serious as it could be, and I must not overlook, of course, the steps taken to hide the crime. The steps taken which if one ponders it, certainly makes the crime even worse. If you could say that the murder of your parents is something that could be made worse. I've tried, even though I've had to examine carefully the evidence, not to think about it. I've tried not to think about how or what steps were taken or how these things even took place. I don't wish to engage in that speculation at sentencing, but I recognize that the jury found Mr. Halderson guilty of mutilating both bodies, hiding both bodies, and presenting a story to law enforcement to try and lead them on a completely different path than what had actually occurred. And that he took steps in those actions which really robbed those people of dignity. But fortunately, their dignity is in whole here in these people that remember them, these people that are here today because of them. I appreciated learning more about them, and my condolences go to every member of their family. There's no foregone conclusions in sentencing. I've learned that since my time on the bench. I've learned that each case is different. Each case demands an individual examination. And sometimes I will confess I sit down not knowing what I'm going to do or not even certain which direction I'm leading. So I appreciate all of the statements made by counsel here and in writing, recognizing that the determination doesn't come until this point and nothing is foregone as far as a conclusion. This is the third individual for which I've had to make this determination. And similar to ADA Raymond's comments, I've had to sentence a host of other people up to this crime, where you can observe a lot in the background of the individual that you end up wishing hadn't been the case because they might not have come to the point if they had had a better foundation. It is to Bart and Krista's credit the foundation Mr. Halderson enjoyed. And it does not explain what happened here. And as everyone has discussed, there may be the ability to have rehabilitation throughout some course of time. And that's why the defense requests that that be kept in mind as to the determination of eligibility for parole. But in all honesty, I must say that as a wiser judge indicated to me once, you should sentence people not because of your anger, if indeed you're fearful of them, and not utilize the same standards for both. I cannot conceive of a way to fulfill my duty to protect the public that I serve were I to perceive that at some point in time, an individual who committed these crimes should be released back into that public. I cannot grant to Mr. Halderson the generosity of spirit and empathy that his grandmother has for him. Empathy which his own parents would surely have had were he just owned up to what he had deceived them about. I cannot say to the community here in this room or at large in this county that Mr. Halderson should have the ability to be reviewed and considered for release back into our community at any point, despite his young age at this point in his life. The gravity of these offenses and the need to protect the public outweigh the potential that there could be that at some future point he should have presence among us. Now, that is not to say that he may not have the possibility of presence as a member of his family in the future. That is up to those folks and he, and that's mentioned in the defense memorandum regarding a hope that someday there might be a reconstruction of a relationship. That's all well and good. I would wish that for anyone, because I don't like telling his grandmother that I'm not able to give her the relief that she's asking for here out of her love for her grandson. I cannot do that. I have to, for this sentence, ensure that the only time Mr. Halderson comes back into the community is to have the privilege of a burial that he denied his parents. And so on counts 1 and 5, per statute, I sentence him to life in prison, and pursuant to section 973.014, sub 1G3, I find that he is not rather superfluous, to say the least, but at the same time, I absolutely acknowledge that we may be in a completely different position here had he committed the acts of homicide, but then stopped and took other steps to accept responsibility and sought forgiveness of everyone. Because what happens with a weapon in a moment of panic is different than what happened over those 48 to 72 hours. The events of which I don't wish to think of or consider once again, having listened to the evidence and observed the testimony and the physical evidence. So to make this quite simple, I will impose maximum terms concurrent to each other and concurrent to counts 1 and 5 on each of the other counts within the information of which the verdict convicted Mr. Halderson. I do believe that by imposing the maximum, I'm recognizing the severity of those individual acts, but there is a life sentence here, so making them consecutive does not undermine the gravity of that, given the maximum penalty involved. I determined, by my calculation, 253 days of credit that the judgment of conviction would reflect from July 8th, 2021 until yesterday's date. And I will waive the court cost assessments and surcharges on each count based upon indigence, the balance on each of the victim witness fee to be payable during the course of his confinement. Is there any restitution being sought?
No, Your Honor.
Then I will enter an order for zero restitution at this time. I don't have to address conditions of extended supervision, except to the point that there's an extended supervision component of the sentences on the other counts. So I would adopt the recommendations of the department on page 24 of the pre-sentence as to those. Although I recognize that extended supervision is denied under this sentence, so that point is moot. Attorney Brown or Raymond, did I overlook anything in passing judgment?
No.
Attorney Vera or Doral, did I overlook anything other than addressing post-conviction?
No.
Mr. Halderson, you have the absolute right to seek an appeal. You have 20 days within which to start that process. That's through filing a notice of intent. I believe that we have on file the notice that you understand and have been given notice of that right, and most importantly, of that deadline. Your signature's on that document. That'll be placed within the file here. I thank everyone for being here today. We are adjourned. Thank you.